do you need to keep your glasses on?
Well, the bright light does affect my vision, but I will take them off because I need to put my reading glasses on.
Okay.
So I will be taking them off throughout the day, but if...
You do whatever you feel comfortable with.
Well, thank you.
All right.
I appreciate it.
Okay, good.
He had medical surgery about a week ago.
Okay, and?
Eye surgery.
All right, I already said he won. All right, very good. You just put them on and off when you want them. You hear me? All right now. You may be seated. Mr. Ambrose.
Yes.
Is this your motion?
It is. Ronald Ambrose appearing on behalf of Robert Bashara. Your Honor, this is our motion for a new trial. We raised a number of issues.
You got a pen over there, Mr. Bashara?
I do not.
Give him something to write with, please.
Thank you, Your Honor.
And you have some paper?
I have one now. Yes, I do. Thank
You
you.
got some paper? Okay. So let him get his stuff together, Mr. Ambrose. We might be here all day, I feel. Are you ready?
Yes, Your Honor. This is our motion for a new trial. We raised a number of issues in this case, everything from ineffective assistance of counsel to confrontation clause issues.
No, my question is, what issue didn't you raise? Because you did thoroughly.
I appreciate that. But, you know, I know this case has been played by...
I'm going to tell you right off the rip what I want to do. I want to go ahead and deal with this ineffective assistance of counsel. I think that that's the issue that's really paramount, and I'd like to deal with that first if we could, okay?
Okay. There are witnesses that Mr. Bashara wanted to be called. The evidence that he wanted out there was not presented. The case, in this case, Jane Bashara her body was found January 25th, 2012. 2 days later, without any evidence whatsoever, Bob Bashara is named as a suspect. No evidence whatsoever. 2 days after that, Joseph Ganz walks into the Grosse Pointe Park police station, confesses to the murder, and they release him. 15 months of investigation. We got 300 witnesses being interviewed, 70 subpoenas, and still no direct evidence whatsoever of Robert Bashara's involvement in this crime, except for Joseph Ganz, who doesn't testify at trial. The case started bad and ended worse. There are a number of errors that...
Let me stop. Mr. Winchester,
yes.
If you're late again, I'm going to sanction you. No more late reporters. Do you hear me? I'm going to fine you. You hear me, Mr. Winchester?
Loud and clear, Your Honor. Thank you.
Okay, very good. Go ahead. 15 months later.
Yes.
Okay.
Still no...
I know where you're going.
Okay.
But can we get up to Lillian Diallo and Mr. McCarthy? I know it's some...
Sure.
Let's just get to them. Because ultimately, that's really where the ball rests as far as an ineffective assistance of counsel goes as to his representation at trial.
Right. And, okay, so the evidence in this case, key evidence in this case, is Jane Bashara's clothing. Where is her clothing? Her clothing gets destroyed or is gone, and that's just unthinkable in this type of case. That clothing had significant value to the defense, especially when we're dealing with another person that Joseph Ganz was involved with on the day of the murder. He's found with J.J. McKee at a bar drinking. And this is on the evening of the murder. So that evidence right there is key to this case, as well as a number of other issues.
I understand.
And there's no Brady motion that's filed in this case. And that's one issue of the ineffective assistance. Okay, that such a key piece of evidence.
Okay, but, okay. Is that it?
No.
Okay, let's just deal with the ineffective assistance of counsel as Lillian Diallo and Michael McCarthy. Let's just get to that.
Okay.
Okay, please, I mean, you've given me wonderful factual, and I've read it, I'm familiar with it, I lived it, so let's just try to get here so we can determine, number one, if we need to present witnesses and have an evidentiary hearing, okay? So let's just get up to speed with that, okay?
Fair enough.
All right.
Okay, there's no motion for Brady violation.
Okay.
All right, that's key to this, a key issue in the case. That clothing being destroyed, there's no reason why that clothing was not there.
You said that.
Okay, I'll move on. The fact of the jury selection in this case.
So let's back up. Okay, we know the clothes are gone. What are you saying that the lawyers did or did not do that makes them ineffective? I need some more linkage with what they did or did not do.
They failed to file a motion for a Brady violation.
Okay.
I mean, that's
Okay. Next
textbook.
issue.
Okay, the jury selection process and the attorney's involvement in it. Now, at the beginning of the proceedings, it was...
Now, let's back up. Proceedings, trial, pre-trial, special trial. Can we get a little bit more specific?
Okay, prior to the jury being selected, there were certain procedures put in place about questionnaires being sent out to prospective jurors. Okay?
Very good, okay.
All right. Mr. Bashara is granted a jury consultant, but the whole process of the jury being selected was rendered null and void when they weren't given advanced...
They being...
The attorneys not being given advanced questionnaires so that they could sift through those in order to weed out the jurors that had already expressed a bias. And so...
Wait a minute, hold on for a minute. Are you saying that the defense attorneys did not get the copy of the answer to the questionnaire?
Not prior to the trial starting, or not prior to the day of the jury selection.
Okay. Okay, so you're alleging that when the court drafted the questionnaire, they were submitted to the jury, prospective jurors. The answers, the questions that they got back, those were given to the attorney.
No, I understand that, but on the day of the jury being selected, they didn't have a chance to weed out the...
You're wrong. See, you're wrong, first of all. Okay. When we did the jury selection, prospective jurors were given those questions, the questionnaire. We then brought them back. They answered them. Each side, they were given copies of their answers. The ones that indicated they just could not be fair, they were eliminated. The remainder, they were the ones that the pool was made up of. So they had privy to it, but we'll get into that more in depth so that we can have, as far as the court testifying, we may need to hear from the attorney. But procedurally, but go ahead.
Well, that doesn't...
Go ahead.
Okay, the transcript of the jury selection clearly states that these jurors, some of these jurors had their minds made up already. And each and every one that was asked, you know, who you have a bias against, they had a bias against Robert Bashara. Not one of them said that they had a bias in favor of him. And so why weren't those, and my question is, if the jury selection, or the jury questionnaire showed that, why weren't those individuals separated from the rest? Because they made those statements in front of everybody else in the jury pool. And it just taints the whole process. It doesn't...
Next issue.
All right. This is a key component of the case is, you know, I mentioned some of the witnesses that Mr. Bashara wanted and some of the evidence that he wanted presented. And Mr. Bashara has filed an affidavit in support of this motion with regard to his relationship with his wife, Jane Bashara. And
I looked at it.
okay, and it's the jury was never given the context of the marital relationship, the physical limitations of each party, and their general understanding of their marriage and how they wanted their agreement, per se. Now, that affidavit states, in particular, that in mid-2000, that both my client had medical issues and so did Jane, but they had
Medical sexual issues.
That's correct. And this was a reason. You know, Jane basically says, hey, you know, she said, don't embarrass me, don't embarrass the family, whatever you do. She didn't want to know about the specifics of it. She just had those two criteria.
And that came out of trial, I thought. Maybe I would.
And certainly not the medical aspect of it.
Well, the medical aspect did not.
Right, and that's one of the claims that Mr. Bashara is making, is that if the jury would have known that fact of why he was engaging in this type of lifestyle, well, then it gives the jury some sort of a context that he's just not out there philandering without...
But this is what was ironic to the court. Mr. Bashir, all due respect, does indicate that his wife has some limitations.
Right.
Okay. But he just very briefly talked about his own limitations and why he was engaged in that behavior if neither one of them could engage.
It was, I thought, pretty well documented or pretty well stated throughout the trial that he has erectile dysfunction.
Right, so if he got erectile dysfunction and she has some physical, sexual problems, is that a basis for being engaged in that behavior? In that lifestyle? So that's a choice, that was a choice.
It was a choice of his, and his wife didn't want that type of relationship. She considered it weird.
What?
His alternate life, that type of...
How are you saying that because she had a medical problem sexually, that tied into his desire to be in a lifestyle if he can't perform?
There are other ways to...
Oh, we're not going to get into that.
Well,
Okay.
You know, hey, put it this way.
Let's move on. Okay, next issue.
And I do want to state this for the record, that at the beginning of the whole proceedings, Your Honor made a statement that this alternate lifestyle, this bondage, discipline, sadomasochist, it's not relevant to the case, it has no bearing on the case, it shouldn't be involved in this case. But what did the trial end up being? Those 300 witnesses that came in and testified, it was all a character assassination. That's what all it was. And so that's why Mr. Bashara wanted these other witnesses called, so that they could put a human face on this guy.
Hold on for a minute now. We're not in trial. We'll slow down. The other witnesses specifically, you're trying to make a prima facie showing to the court of who we need. Let's go into detail about the witness. We already talked about JJ. We talked about J.J. McKay. Let's talk specifically about the witnesses that Mr. Bashir wanted to put forward that would have aided in his defense.
Well, certainly the...
Because in your pleading, it's like the neighbor of Mr. Ganz. There's no name. There's no affidavit. Can you give us a little bit more specificity, please?
Yes. And I think it is stated in...
their affidavit. Do you understand what I'm saying? There was no name. What I got was the neighbors of Mr. Ganz, about his aggressive behavior, etc. But there were one or two names, but there wasn't anything in detail. Can we go over that, please, Don? Yeah,
those, and if I didn't put it in my motion, I would have to look at all my records to find out the specific names. But it is documented that Joseph Ganz had a violent history, a very violent history, that he was subject to explosive behavior, that also that he hated, and this is it, that he hated women, and that he had expressed those views to others. And some of them are inmates that he expressed those views
But,
to.
Mr. Ambrose, you are very skilled lawyer. I need to know specifically who you want, or who Mr. Bashara wanted specifically,
Okay.
that would tend to show that, that would help Mr. Bashara. But you're saying generally, the people in lockup, I mean, it's not specific.
Kevin Hall, Michigan Department of Correction,
Kevin Hall?
he's with
Can you spell first and last name?
K-E-V-I-N.
Okay.
Hall, H-A, H-A-L-L.
Okay. And he would have testified to?
Speaking with Joseph Ganz and Joseph Ganz making certain admissions to him as to his hatred of women.
And this was during what time?
When he...
when he was ultimately convicted, when he was being held, I don't know.
When he was convicted.
After he was convicted?
Yes.
Who else? Okay, see what we're going to do, Ms. Ambrose. Ms. Ambrose, we're going to skip over that, okay? Because there are a number of issues that you raised, so let's come back to that.
And just for the record, they are stated within Mr. Bashara's motion that he filed in pro per.
Okay,
and
well, I didn't get that.
It was submitted at the time of sentencing.
Okay, okay. Well, you should have, if I denied it, then why did you just renew it or recopy it up?
I used a good portion of it in,
Well, it's not.
and I made reference to it in my motion.
Okay, very good. Well, you need to do an amendment, okay? Because I'm looking here in your generic information about allegations of what lay witnesses would say. I don't have a specific, and we need to do that.
Okay.
Let's just move on to another area, okay?
Okay.
I think the next one we'll talk about the change of venue or whatever. Wait, slow, would you stop?
Yes, ma'am.
Now go ahead.
Well, the motion for a change of venue is another aspect of the case, and in some respects does get to the ineffective assistance of counsel for not raising that issue. Can't remember a case within this community that has garnered such media attention as this one. And it's not only the media attention that it's garnished, it's also the proceedings. I mean, this was for 15 months until the time of his, more than that, until the time, from the day of Jane Bashara's murder, January 24th, 2014, until for another 2.5 years at least, the media was on top of this case.
Okay.
And for a motion for a change of venue was needed in this case because it was completely one-sided in terms of the jurors' bias and the whole community
Next
being
issue,
biased.
And this is what I'm saying to you. What I need you to do is, opposed to going in detail, give me a brief synopsis so that we can do number one. I can determine if there is a after I hear argument, is there a prima facie showing that there's a necessity to conduct the evidentiary hearing? And if so, and I rule it, we're going to conduct that evidentiary hearing. So I don't need you to go in depth because you'll have an opportunity, if Mr. Bashara waives his attorney-client privilege, to bring those people forward and we can have that, okay?
Yeah.
So then that was the first, so we talked about the missing witnesses, which I'm going to let you amend, okay?
Right.
And then you want to talk about the change of venue.
That's correct.
And we already talked about the closing and whatever. Just so I can make a determination, that's all.
Okay. The change of venue and the jury selection process kind of go together. I put those together in one separate issue. The constitutional right to present a defense. The playing field in this case was completely slanted. And I don't want to continuously repeat myself, but for 15 months, the prosecution was able to put on or to present, in essence, a character assassination of Bob Bashara. These attorneys, in a sense, didn't...
These attorneys, we had about 10 of them.
I understand.
So which one are we talking about specifically?
Well...
I mean, it's okay to say their name.
Okay, Mr. McCarthy and Ms. Diallo, they have the case in April and 2014. Ms. Diallo says that she has 10 boxes of discovery. The case starts 4 months later. He's entitled to an investigator, and you know what? Or he was given an investigator, but the investigator wasn't allowed to do his job, and that's Joseph Bruce.
Tell me how.
Because he wanted to locate J.J. McKee, who, as I stated earlier, was with Joseph Ganz on that evening of the murder. And when he submits a voucher to get paid, he's denied payment. So at that point, his investigative services are hamstrung in a sense because he's not allowed to do his job. He wants to find J.J. McKee, but he can't do skip traces to find him. He's not getting, Joseph Bruce is not getting...
What does that have to do with him not being able to do his job if after the fact he didn't get paid?
Well, it's during the proceedings he didn't get paid. He was supposed to submit monthly vouchers, and
Are you saying the court didn't pay him?
didn't pay him the complete fee that he had requested. And
that's at the end, so why couldn't he find J.J. and when he was appointed? You said he wanted to look for J.J. McKee.
That's correct.
And you're saying that because he didn't get paid at the end, he couldn't look for him in the beginning?
Well, he was denied, he was told that he wasn't going to be getting paid for these types of services, so he didn't do his... Well, he had submitted vouchers to administration, and he was being denied his request. So I think as a...
So you're saying monthly he was presenting a bill, and this court said we're not paying you?
They didn't say, they just didn't pay him. Until I think he got a portion of what he had requested, but certainly not all.
All right, come on, next issue.
All right. But what I wanted to, Joseph Bruce wanted to locate J.J. McKee because he was seen with Joseph Ganz on that evening, and what happens the day after the murder is J.J. McKee, his vehicle gets scrapped. And that issue, that information was never brought out at the trial. Why, there are a number of, we can infer a lot of things from that. From J.J. McKee being with Joseph Ganz on the evening of the murder and the day after J.J. McKee's vehicle getting scrapped. So, and, to try to locate, the prosecution tried to locate J.J. McKee. They said they did attempt to talk with him, but he was quote-unquote uncooperative. So I don't know if he was uncooperative because they didn't give him information that they wanted, or...
Okay, I asked you briefly to talk about the ineffective assistance of counsel. Okay, so that's one issue. I don't see how that's related to the defense not being able to put forth an effective defense about him not being paid. But anyway, we'll deal with that. This next issue.
Oh, well,
Counsel,
okay.
next issue.
All right.
Specifically to the ineffective assistance of counsel, if you could.
And that is, the failure to present a defense is a separate issue in this case, and it does relate to the attorneys, Diallo and McCarthy, not being able to do their job properly because the investigative services that were granted were being pretty much handcuffed. And not allowed, Joseph Bruce will testify that he really wasn't allowed to do everything that he wanted to do.
Next issue.
All right. This goes, issue number 4 in the brief is the Sixth Amendment right to confront his accusers. And that's, everything was done in this case to prevent, at least it seems like by the prosecution, to prevent Joseph Ganz from testifying. They didn't want his testimony because he was going to be exposed. There's no doubt about it. His interviews did not match with the facts of this case at all. He testifies that this murder occurred at 7 o'clock. Well, that doesn't match with the facts of this case at all. He was going to be exposed in a number of ways. He gives an interview to the police where he says Bob Bashara held an automatic gun pointed at him. There's no automatic gun in this case at all. And so he was going to be exposed in his testimony if he ever got to testify. Now, the prosecution gives Joseph Ganz a plea agreement of 17 to 28, what have you, and in consideration, he was supposed to come in and testify truthfully. Well, when it comes to the time of trial, he tells everybody, I'm not going to testify. What did the prosecution do? They didn't try to yank his plea. They could have easily yanked his plea. He could have been sitting in prison for life. But they didn't do that. And it just astonishes me that wasn't done.
How does that go to ineffective assistance
Well,
of counsel on behalf of Mr. Bashara?
I am jumping around, but
and that's what I've asked you not to do.
well,
Please,
I had thought.
and this is why. What I need to do is make a determination based on what you're alleging and brief facts so that we can determine, is there a prima facie case, a showing of ineffective assistance of counsel, and would a evidentiary hearing be mandated to flesh out these issues, okay? But what you're trying to do is do a closing argument in front of me. And I don't need you to do that because after we deal that, we'll deal with the other issues.
Okay.
But I want to bifurcate it. Can we do that?
Sure, okay. Let me go to this aspect of the case. Okay, during jury deliberations, probably a key aspect of any type of case, a primary area where the jury is being informed of what the elements are, what reasonable doubt is, what a presumption of innocence is, all of these things. And the jury sends out and this goes to ineffective assistance of counsel, jury sends out a note saying that they want a definition of reasonable doubt. Well, the parties initially agree that, yes, we're going to give that standard reasonable doubt instruction. But in addition to that, and without any type of prior information, and no disrespect, but the court gives a reasonable doubt example to the jury that indicated Bob Bashara, or indicated a hypothetical person was engaged in infidelity and that you really can't believe anything that this person says. In essence, that's what the example was. I presented it verbatim within my motion. You can, it's in there. But at the end of that, the court asks the prosecution, do you have any objection to that example? They say no. Shockingly, defense counsel say they're satisfied with that example. And, when a jury sends out a note as to the meaning of reasonable doubt, would suggest that maybe they're not, to me as a defense attorney, I'm thinking they are thinking about this case and they are actually, this is to our benefit, but that was set aside with, no disrespect, with the court's instruction or example of what reasonable doubt should be. And what I'm saying is that there was no objection to that. There should have been, without a doubt. And Your Honor has granted me the authority to, to supplement with the specifics. I would like to do that.
Okay, very good. Okay, that's enough. I heard enough from you. What do you want to say?
As the court is well aware that the defendant is presumed to have been lawfully and factually proven guilty of these crimes. And it's defendant's burden to prove by reasonable probability that he was not. I guess the first question is to whether we even need to have an evidentiary hearing in this particular case. The defendant's issue seems to fall into two different categories. The first category is that these particular witnesses were not produced, even his attorneys didn't produce any of these witnesses that should have been called. As the court has indicated, a lot of that has not been fleshed out in the defendant's motion. No factual predicate has been presented quite yet.
Say that again, please.
The defendant hasn't quite fleshed out those particular issues on those witnesses. There's been no witness list that's been presented to the prosecution. What's presented in the actual motions is just a bare bones skeletal outline as to some unnamed person who's going to testify with important information. That in itself doesn't set out a factual predicate. Now the court has indicated that you would give the defendant the opportunity to amend that. I would certainly wait until I receive that amended motion before I can address any of those issues. But as it is right now, because no factual predicate has been
Okay, get beyond that. Let's talk about
Sure.
The fact that they didn't file a motion about the missing clothes, the fact of they wanted to try to locate this J.J. McKay, according to what the defense says, present defense, and that the trial defense wasn't interested or didn't do what they should have done. Basically.
None of those motions require an evidentiary hearing. What an evidentiary hearing would do is if the court requires additional testimony in order to decide a case, that's when we have an evidentiary hearing. In all of those situations, whether it's the Brady claim, the venue, change of venue, the jury selection, all of these are questions of the record of law for this court to decide. So even if he put up 5 witnesses, Ms. McCarthy, Ms. Diallo, defendant, everybody, and they all testified, yep, we made a huge mistake, we should have objected, we should have presented this motion, so on and so forth, that doesn't decide the case. What decides the issue is whether this court believes that by failing to make this motion, that defendant was denied a fair trial, whether he suffered any type of prejudice, why by a reasonable probability the failure to do this made a difference in the case. And in none of those situations require an evidentiary hearing, obviously, but in none of those situations I think the court can make that determination that any prejudice occurred that requires a new trial.
Well, I'm not going that far. Listen what I'm going to do. I've heard enough from you. I'm granting the evidentiary hearing in this particular matter. I'm satisfied there's a prima facie showing of ineffective assistance by the defense, and I want to supplement this record to find out, does it tantamount to actual prejudice to grant Mr. Bashara a new trial? So I'm ready to go forward. And we have the witness. Now the issue is Mr. Bashara ready to waive his attorney-client privilege?
Yes, Your Honor.
Mr. Bashara, stand up.
Yes.
Stand
Oh,
up.
I'm sorry, I didn't hear you. Excuse me.
Well, listen. Raise your right hand. You solemnly swear or affirm testimony about the witness matter, truth, the whole truth, nothing but the truth, so help you God.
I do.
You understand you have an absolute constitutional right to not waive your attorney-client privilege. Do you understand that?
I do.
And the court is requesting or requiring if you want to do that because there may be information that the defense had or that your lawyer is protected, that they now will be able to be in a position to expose to determine if this court is satisfied that they did their job. Do you understand that?
I do.
And do you understand whatever that may be, by me accepting your waiver, that means they have the right to get on that stand and say exactly what you said so that this court can determine whether or not the allegations that's put forth by your lawyer have been substantiated to grant you a new trial. Do you understand that?
I do.
And based on your discussion with Mr. Ambrose, you are prepared to waive your attorney-client privilege.
I am prepared.
And you understand that that testimony potentially can be used against you.
Well,
Anything that you say about that you had revealed to your lawyer. Do you understand that?
Absolutely.
I can use it for you, or it can be used against you. Do you understand that?
As long as those people are telling the truth, then I
I can't
understand.
determine. Do you understand that?
I do.
But what I'm saying is the privilege.
Right.
You have a privilege to say, I don't want them to say anything. They can't take a stand. Are you willing to waive that
I
privilege?
am.
The reason that, okay, and you discussed it with Mr. Ambrose. Do you
I have.
understand that? There will be a record of what they say. Do you understand that?
I do.
And based on that record, I would have to determine whether or not they were effective in presenting you a defense as guaranteed to you under the 61. Do you understand that?
I do.
Very good. At this time, the court's going to make the following finding that the defendant's waiver to his attorney-client privilege is knowingly voluntary and knowingly voluntary and understandingly made. The court is going to accept it. I'm ready to go forward. Are you, counsel?
I am ready to, my only question on that, Your Honor, is I just want to know exactly which witnesses are going to be called, because as I've argued in my...
May I?
Yes.
We're going to deal with the lawyers. I'm going to give Mr. Ambrose, it's 92 pages. This was filed some time ago, and I'm somewhat at odds to why these specific witnesses were not delineated that would bring forth this new information. But who I would like to go forward with, the attorney and Mr. Bruce.
Certainly, Your Honor.
Okay, as far as the other attorneys are, the witnesses, how many witnesses are you talking about?
Well, after today, there.
I'm talking specifically that Ms. Diallo and Mr. McCarthy were aware of but didn't choose to present. That's what the witnesses I'm talking about. They can't present something they didn't know.
Right. I'd have to consult. I don't want to.
Because we're not going to have a retrial of it here. You understand that?
Understood.
So how many we talking about approximately? Six.
6.
Okay. This is what you're going to do. I'm going to need their names. We're going to need a statement of what they're going to say. We're going to need affidavits. So, of course, it's going to give you 30 days. Could you get that in 30 days?
I could.
Okay, very good. So this is what the court is going to do. I'm going to indicate that that's going to have to be filed with the court no later than those names February 2nd with the support and the people, and we can come back on the 13th to conduct the continuation here. I can't do it.
I'm sorry, Your Honor. Did you say February 2nd?
I'm saying October 13th, I'm sorry. Okay? October 2nd, and we can come back on October 13th. Is that okay? You want to take a look and see if it's okay?
Thank you.
Yeah.
Should be a
Your
good
Honor,
date.
on the 13th, I have, I'm in the Court of Appeals that morning.
What about the 14th?
I could do the 14th.
Counsel at law?
That's a fine date.
Okay, very good. All right. Now, I can't find them, I can't locate them, but this is what they would say. They're not coming in here. Do you understand that, Mr. Ambrose?
Yes, Your Honor.
Do you need me to appoint an investigator?
I think right now I would like that. Yes.
Okay, then that's what it's going to be. Just give me an order, okay? Would you be quiet?
I'm sorry. Excuse me.
You're doing fine without your help.
Okay.
Okay, very good. This is what the court is going to do. I'm going to give a 10-minute recess so that we can assemble ourselves together, and we'll come back, let's do it 10:30, and I'm ready to go forward at that point. Thank you. And stop talking so much, okay? You.
Okay.
So just write it down to the 15 minutes.